now we are moving out of this frontier to the private enforcement of the Digital Markets Act. So the regulation, the very recent regulation that now mandates obligation on specific firms operating on digital markets. So in this lecture, which is also part of ongoing research with Marco Botta, we are going to see why we are moving from competition policies. No, we have moved from competition policy to the regulation of digital platforms. Then delve some, expand a bit the scope of the DMA, because we can have private enforcement of the DMA as long as the DMA applies to specific undertakings, in this case, gatekeepers, and as long as these gatekeepers are subject to the obligation and breach the obligation that the DMA imposes. And then, yes, in the last part, really focus on the private enforcement of what we see the DMA states. So a basic premise of any lecture on digital markets is that digitalization brought innovation and many benefits for society, new types of products and services, new ways of delivering existing services and products. So we should start, let's say, with the theory that digitalization is good. Okay, so not everything and all the time that we hear digital platform, we should think of bad things. But of course, bad things can happen also in digital markets. And starting with the details, with the basics of how digital platforms work. So we are exposed to them on a daily basis constantly. And so we have platforms, which in the DMA we will see are called gatekeepers, operating on multi-sided markets, and in this sense, connecting different types of users, let's say some upstream as business users, and we can have different types of business users, advertisers, content creators, and sellers, manufacturers. And on the downstream sides of the multi-sided markets, we have end users, all of us. And in these types of firms operating on digital multi-sided markets can pose the usual types of competition law problems. So, of course, we can have problems of exploitation or unfair condition imposed by these very large platforms, gatekeepers, on either side of the multi-sided market, so on either the end user side of the market or the upstream business user side of the market. So really, because of their importance and power, they are really, we will see the DMA calls them gatekeepers. They are really a gateway for business users, SMEs, any type of business users to reach and sell, for example, online, provide advertising spaces. So for sure, given their market power that they have acquired, they are able to impose unilaterally the rules of the game on either us end user or upstream business users. Then there is a problem of horizontal competition, inter-platforms competition. So of course, these firms, for example, Google Search, compete horizontally with other search engines such as Bing, but can also compete in a certain sense with more innovative services such as ChatGPT. And so there is this dimension of inter-platforms competition. Then we have a vertical concern of vertical integration by the platforms, where, and this is, let's say, the intra-platform competition dimension, where the competitive problems are between the platform and certain business users. Think of Apple iOS, Apple with its own operating system, also providing an app for listening, for streaming music, Apple Music. And here the concern is the, let's say, foreclosure of competitive music streaming services such as Spotify or Amazon Music. So this dimension of competition. Last but not least, there is also a dimension of conglomerate competition. for those services that are so-called ancillary or complementary to those of the platform. And here we're not necessarily talking of digital services in the traditional sense. These can be ancillary services. For example, for the Amazon marketplace, an ancillary service is the one of mail delivery. With Amazon extending, let's say, his business operation also in that sector, and here competing with non-traditional digital companies, with the mail delivery companies. So there is also this dimension of extra platform competition. But financial like methods of payment can be another example of extra platform competitive problem. For example, with Apple extending into the payment market with Apple Pay, and so they're competing with more traditional financial firms. Okay, but why do we have these market problems? Because digital markets present natural monopoly features, which are more typical of network markets. First of all, it's extreme scale economies, and this, of course, is an entry barrier. Strong direct and indirect network effects among the platform's multiple sides, another entry barrier that also somehow causes a certain way of competing that is not competing in the market, but rather competing to be the best one in the market and win the entire market. So winner takes all competition. Another aspect very important for the role, let's say, for the market power of the platform is the role of data. Of course, these are digital markets where the digital services are apparently provided for free, and we consumer pay with our personal data. So the platforms providing the services for free have access to a large amount of our data. And yes, in principle, data is like an immaterial asset that can be rivalrous and so used by different firms without consuming itself. But there are still lock-in effects and behavioral biases on our side of consumers, and that limit the data portability and multi-homing, so using the same service from different providers. Thanks to the access to our data, the platform can also improve the service, make it more personalized, and so in a certain sense make us more tied to the platform that we are using, and also this provides a competitive advantage to the largest platforms. And regarding the conglomerate effect, thanks also to a technological advantage that these firms have in terms of artificial intelligence technologies and engineers that they have as human resources, can analyze trends in the big data that they collect and expand to profitable activities that are in neighboring markets. And so because of all of these features, so the natural monopoly features and the role of data in digital markets, these markets tend to tip, and dominant online platforms we have seen have been subject to several competition law investigations. You have a list, non-comprehensive list here in the slides, but we have seen very novel practices being subject to investigation by the public antitrust authorities, and have also reached the European courts, national courts. So really a variety of cases where allegedly there has been a market failure, a failure in the digital markets, and so that required intervention by the competition authority. But all of these cases somehow imply some recurrent market failures that, in theory, at least justify ex-ante regulation. So passing from ex-post competition enforcement, more ad hoc and sporadic, and remedying the after the fact to ex-ante regulation. Besides the abuse of dominance cases, another, let's say, market failure that has been witness is the one of killer acquisition. So digital incumbents acquiring small startups that were potential competitors in the medium to longer term. Another reason for regulating instead of relying just on antitrust is in the past, at least, antitrust has been slow to act. With, of course, all the procedural guarantees, the right of defense, the evidentiary burdens on the antitrust enforcers, these being either the competition authorities or private plaintiffs. The proceedings are quite long. And the fines also not really a deterrent factor for very large firms such as Google. And also there's been some political reasons behind the decision, let's say, of European policymakers to intervene on the internal side and internal market perspective. Of course, the EU intervention ensures uniformity against fragmented EU member state initiatives, but also somehow, and this was also hinted by Francisco Marcos before, also the willingness to promote, let's say, entry by European firms, European innovation against the large foreign digital incumbents. And so we arrived to the Digital Markets Act, so Regulation 1925 of 2022. And here you have a timeline. We are really at the edge of the timeline because after entering into force, we have the first designation of the firms that will be subject starting from 6 March, so next week, to the obligation that we will see. We have the designation decisions, and really, next week, the obligation will kick in, and the designated gatekeepers will have to comply with these obligations. So a first point that we can make regarding private enforcement is that any infringement can occur after this 6 March. Nothing, in 6 days, yes. And it would be interesting by this date next week, because the gatekeepers will have to provide the European Commission, which is the main enforcer of the regulation, with a compliance report. And the regulation also states that there would be a non-confidential version of this compliance report, which in principle would be very important for private enforcement and for plaintiffs. Also, another transparency, let's say, obligation that is in the DMA is the one of submitting an audit of customer profiling techniques. Here again, a public version of this audit report should be made available and would be important in private enforcement of the regulation. So just quickly, by raising hands, in your view, among the mentioned ones, which is the main reason for the adoption of the DMA in your perspective? So because antitrust enforcement was ineffective, or not enough deterrent, or prevention of fragmenting the internal market, or industrial policy, so EU versus the rest of the world. So the legal framework, what's inside the DMA, objectives, these are close to competition law objectives, but not really identical. We can talk about complementarity, as Lena was saying. So first of all, contestability, so as the ability of undertakings to effectively overcome barriers to entry and challenge the gatekeepers on the merits of their products and services. And then on the other hand, you have fairness. So this fairness is not directly defined, but relates to the imbalance between the rights and obligation of the business users, where the gatekeeper is the party that gets an advantage. And so here, the rules of the DMA try to improve fairness and limit gatekeepers' ability to impose the rule of the game unilaterally. And of course, as exclusion and exploitation in competition law are intertwined, also contestability and fairness in the DMA are intertwined. So the lack of contestability can enable the gatekeeper also to engage in unfair practices. And
maybe just one point to add, to emphasize, is that if you read the preamble, fairness, it's about the relationship between the gatekeeper and the business users. End users has not even mentioned. And this has, we will discuss it later, important implication when we talk about the legal standing, who has the rights to start a private enforcement action for breach of the DMA obligation. Please.
Sorry to interrupt. I will shut up. there is no definition of fairness. There's just a definition of not fairness, and which is, we know what we don't want. Because if you read, where is the definition of fairness? And what is fairness?
Okay, and then there is the first, let's say, the entity that are subject to this regulation are so-called gatekeepers. So these are the firms that control the rule of the game within a digital ecosystem. And as an asymmetric regulation, the DMA obligations are only applicable to the digital gatekeepers as designated by the Commission. So there is first an objective requirement for the designation as gatekeeper, and this is providing a core platform service. We will see what these are in the next slide. And then there are three subjective requirements. First, having a significant impact in the internal market. Second, being an important gateway for business users to reach consumers. And then third, enjoying an entrenched and durable position in the market. And there are, next to these, let's say, requirements, there are quantitative thresholds that function as a rebuttable presumption of gatekeeping status. And it's on the digital platforms that meet these thresholds to notify the European Commission of they meeting the thresholds, and then there is a presumption of status as a gatekeeper that can be rebutted by the firms. And we have seen with the first designated gatekeepers that some firms that met the thresholds here, like Apple with iMessage and free services of Microsoft, were successful in rebutting the presumption of their gatekeeping status. And of course, this list, we will see the list is going to be updated, so firms can enter the list and firms can exit the list, and the update should be every 3 years. Here you have the core platform services, and we have prominent services that we use in our daily lives. You have intermediation services that are those marketplaces, let's say. You have search engines, social networks, and the like. So it's really a very diverse list of services that we use online. Here you have the quantitative thresholds. So, the first one of the impact on the internal market is relates to turnover. So turnover over 7.5 billion euros within the EU and in the past 3 financial years, or a market valuation. Also, there is a requirement of EU operations, so providing the same core platform service in at least 3 member states, so being active in more than just 1 member state. Then the requirement of being an important gateway for business users to reach end users relates to the number of active users. And here you have a difference between active end users on a monthly basis, which must be over 45 million, and then active business users, which must be on a yearly basis more than 10,000. And then the last requirement is presumably met once the user threshold have been met in the previous for the previous 3 years. Here you have the web page of the European Commission, and here you can see the core platform services for each designated gatekeeper. And the one highlighted in green are those gatekeepers that challenge the decision. And so we will have at least a first legal review of the designation by the Court of Justice. And so you have, for example, TikTok ByteDance, so the Chinese social media that challenged the decision, but also Facebook challenge for its Meta marketplace and Messenger app, and then Apple for App Store, Safari, and iOS. Then a first overview of the obligation in the DMA. First of all, and this is quite important for private enforcement. So we will talk about private enforcement. We just focus on the obligation on the left, so the behavioral obligations, and these are those in Article 5, 6, 7, and partially also in Article 13, the so-called anti-circumvention clause. And then there are several other obligations that we can label as compliance obligations, which are vis-a-vis the enforcer. So not really private parties that can not providing a right of action to private parties. These are towards the Commission as the main enforcers and national competition authorities as they are also involved in the enforcement. Other features that are important also for the private enforcement of the digital market regulation. Of course, we have negative obligations of prohibitions upon the gatekeepers, but also positive obligation of acting in a certain way, for example, increasing transparency for the online advertisement services. Each of the obligations, behavioral obligation in Article 5, 6, and 7 addresses different goals of the DMA. So can be contestability, can be fairness, transparency, or can be a mix of these goals. And perhaps the most important, let's say, classification for private enforcement is the legal relationship addressed by this obligation, because you will have the slides, but you will see also reading the DMA that certain obligations are geared toward all users, so these being end users and business users. Then there are some that are geared towards just end users, for example, Article 5.5 on content portability. Then some geared just towards business users, and perhaps we can expect that business users will be the main, probably the most likely plaintiffs in private litigation of the DMA because of the reasons that we know from also the previous lectures. And then finally, those compliance obligations that are between the gatekeeper and the Commission, which will not be subject to private enforcement. An important distinction is also between Article 5 self-executing obligation and Article 6 and 7 obligation, which are subject to a certain extent of regulatory dialogue and specification by the Commission. We don't go through all the list, but just mention and read Article 5.6 of the obligation, which in broad terms prohibits no challenge clauses in the relationships between the gatekeepers and any user. So this is an obligation that is in favor of private enforcement of the regulation, because prohibits gatekeepers from preventing or restricting the ability of users of raising issues of non-compliance with the obligation before like authorities, public authorities, but also national courts. So let's say by law, the gatekeepers cannot prevent private enforcement of the DMA obligations. Finally, remedies, these are very similar to the competition enforcement, public enforcement. You have, of course, the main difference is that there is no need to assess the effects of a certain practice on digital markets, but you just need non-compliance. Non-compliance will have to be motivated, and so some analysis of some description of the why a gatekeeper didn't comply with the obligation will be done on the part of the Commission, but there is no need to assess the effects. And this might cause, of course, problems in private enforcement for those that are called to then quantify the effects of non-compliance. And then, perhaps it's not a major addition, but the fines can be higher than in competition law when there is a repeat offender of the same violation. And also, in theory, structural remedies would be more available compared to, or hopefully more used compared than competition law enforcement, traditional competition law enforcement. There is a role also for the national courts.
Just about the remedies, just to clarify, the point, not the last one, but that one before Article 18, about the structural measures. So structural measure, which basically means the unbundling of the gatekeepers and forcing the gatekeepers to sell some of its core platform services to reduce its market power, is basically impossible to achieve. So the standard is extremely high. It requires 3 non-compliance decisions against the same gatekeepers for the same violation in the last 8 years from the moment in which the obligation enters into force fully, which is 6th of March 2024. So we will not see any structural remedy before 2030 in the best scenario. So we really talk about behavioral remedies, obligation, which are ex ante, and exceptionally, we will see some fines in case let's say, the gatekeepers don't comply. This is about public enforcement. Then we will talk about the situation under private enforcement.
Yeah, thank you, Marco. So finally, perhaps just on the role of the national competition authorities, that in the initial proposal, in the initial idea, could only ask the European Commission to open an investigation, and so had a minor role in the enforcement of the DMA. But during the legislative debate in the European Parliament and the Council in the trilogue, their role has been, let's say, improved, and so they are also enforcers of the DMA, and as last Article 38, paragraph 7, they may investigate cases of non-compliance with the DMA obligation within the territory, national territory, and subject to the powers defined by national law. And we will see that Germany, for example, already provided some powers to the Bundeskartellamt. So before turning to the private enforcement part of the lecture, another, let's say, poll by raising hands. So in your opinion, who will be the main beneficiary of the DMA? And so in theory, also the more likely plaintiff in private litigation. So existing businesses who depend on gatekeepers to offer their services in the EU. So this can be any SME on the EU selling online, for example, through Amazon Marketplace, or innovators and startups who will not bear unfair terms and conditions limiting their development. Digital incumbents, so other very large digital players who can exploit the DMA fully. Consumers, perhaps, or you don't know. Somebody goes with consumers. Existing businesses, innovators, lawyers. No, perhaps of course the digital incumbents have the means to also make a lot out of the DMA and entered markets where perhaps they are not so strong and compete with the gatekeepers. Okay. Enough of let's say introduction. Now more on the private enforcement of the DMA.
So thank you, Niccolò. So far, Niccolò has talked about the present. Okay, the DMA is in force since fully applicable since 2nd of May 2023, and the obligation will be applicable by the designated gatekeeper since next week, 6th of March. Now we started the bit more speculative part of the lecture about private enforcement, so about the future, but not about the futuro anteriore, but it's futuro prossimo, so what is going to happen very soon in the near future. So let's first talk about the role of courts in the DMA enforcement. Clearly, most of the cases will be heard by the Court of Justice because all the appeals against the Commission decision concerning the designation of gatekeepers, imposition of fines, potential decision of suspension or exemption for the gatekeepers' obligations, remedy for non-compliance. This is the business of the General Court and the Court of Justice in Luxembourg, so it will not touch you as national judges. But what will touch you for sure as national judges will be the public and private enforcement at the national level. What I mean public enforcement? So as Niccolò mentioned, it's possible under Article 38, no, the point is not this, paragraph 7, for some member states to legislate to empower the national competition authority to investigate cases of non-compliance with the DMA obligation. And we know already that Germany has already done it, and other member states are in the process to do that. So several competition authorities in Europe will have the power to adopt decisions sanctioning infringement for the DMA obligation by the gatekeepers designated by the European Commission. So this will, we expect, to have cases under more, let's say, public enforcement, so administrative courts reviewing decision of the competition authority under this legal basis. Then private enforcement, what we mean, like in competition law, we talk about civil claims for breach of the DMA obligation, breach by designated gatekeepers, and we will see who can be the plaintiff. So if you read the DMA, you will not find any single provisions about private enforcement of the Digital Market Acts. Is this a problem? Does this limit the private enforcement of the DMA? The answer is no. Why no? Because the DMA is an EU regulation, and regulation clearly can be subject to private enforcement in national courts. When they have direct effect, and as you know from general principle of EU law, the regulation have to be clear, unconditional, and they have to grant rights to individuals. Clearly, not the entire regulation has direct enforcement, but certain provisions of a regulation can have direct enforcement, and we will discuss which provision of the DMA can have direct enforcement. Also, from a general EU law perspective, we know that regulation can have horizontal direct effect. So in dispute between, for instance, in our case, and or business users vis-a-vis the gatekeepers. Which are the provisions of the DMA which can be considered clear and unconditional and therefore subject to private enforcement? So clearly, we would exclude, but again, this is our speculation, and then we would like to hear your opinion. We will exclude Article 3, so the designation of the gatekeeper, that is an exclusive business for the European Commission. We will also exclude the decisions of suspension and exemption from the DMA obligation. So this falls under, again, the exclusive business of the European Commission. So what we underline in yellow are the core DMA obligation which can be subject to private enforcement case eventually in the future. And here we can make a further distinction. So we have Article 5, which are the so-called self-executing obligation, which are enforceable since the moment when basically the 6 months of time granted to the gatekeeper is over. So since 6th of March 2024, for instance, the no challenge clause that Nicolò discussed before. Okay, for that there is no discussion that is clear and unconditional. There's been a discussion in the literature about the Article 6 obligations, which are the obligations which are subject to a possible decision by the Commission, which will further specify the obligation mentioned in this article. And here there are two views in the literature, according to Makis Kominos. There is no need for having a further decision by the Commission in order to have possibility of private enforcement, so to have direct effect, while for it, Rupert Postum has argued the other way around. We can have private enforcement, a sort of follow-on action only after the Commission has further specified the obligation. So what is your view about this issue, which is quite important when we talk about the scope of application of the DMA obligation? Which obligation should be subject to private enforcement actions? So only Article 5, those which are clearly self-executing according to the DMA, or also Article 6 and 7, or Article 6 and 7 only in case of follow-on action, so when we have a previous decision by the Commission. I think there is one point, I think we made a mistake from a terminological point of view. When in point 3, we wrote follow-on actions, but we are not talking about follow-on actions after a commission infringement decisions. This is a commission specification decision, okay? That's something different. So far, the commission has not adopted any specification decisions, but still the obligation under Article 5 and 6 are already applicable for the 6 designated gatekeepers.
No obligation to also adopt. We can stay without.
So let's see, who are the possible plaintiffs? So remember what we discussed before. According to general EU law, in order to have direct enforcement of a regulation, the provision of the regulation must be clear and unconditional. And we discussed this about Article 5, 6, and 7, and there is a bit of doubts about Article 6, and it has to grant rights to the individuals. So on this basis, we would exclude that the gatekeeper competitors, so the competitors of the gatekeepers who basically compete at the level of the inter-platform competition, that's what Nicola was explaining at the beginning, would have any right to contest a breach of the DMA obligation by the designated gatekeepers. And we also have serious doubts about the end users, so the final consumers. Why? Because as I mentioned before, if you look at the preamble, when the DMA talk about fairness in the relationship between the gatekeepers and the business users. End users are not mentioned, are really indirect beneficiaries of the DMA obligation. And also, if you read the 24 obligations, very few basically address the final consumer, final users. One, for instance, it's Article 5, Paragraph 2 that Giorgio mentioned before, which basically imposes an obligation for the gatekeeper not to combine and cross-use data across the ecosystem, collecting from different services, unless the final users, the end users, provide the consent to do that, okay? So we could imagine maybe some kind of action from some consumers who are, I don't know, users of some service of a gatekeeper who combine the data without their consent, so in breach of Article 5, Paragraph 2. But again, there are probably 3 or 4 obligations in the DMA that address final end users, while most of the obligations address business users. So the DMA is really about this intra-platform competition between the gatekeeper and the business users like advertisers, merchants, and so on, who relies on the gatekeeper services. And they will have, I guess, legal standing to go to court if the DMA, if the gatekeeper breaches the DMA obligation. Then, talking about consumers, this morning, Lena talked in details about the Representative Action Directive, which entered into force last year in June, even though several member states have not transposed the directive. And Lena has already mentioned that the Article 42 of the DMA directly refers to the directive. So the directive will be also applicable to claims, to private enforcement claims concerning the DMA obligation. So I discovered this morning that Germany, in implementing the directive, extended the scope of the directive to small and medium-sized enterprise, SMEs. But if you look at the directive, if you read it, SMEs don't appear anywhere. So it's really only about consumers, and that's how I expect most of the member states will transpose the directive. So in light of what I have said before, that we have very few obligations in the DMA that concern address consumers and users, in light of the general terms of the directive, I personally don't think we will see in the near future a lot of collective actions by end users, let's say, against gatekeepers. This is at least an expectation. Then, what are the possible remedies? So as Andrea was mentioning, clearly the main remedy would be an injunction. So the party who managed to prove to have legal standing in court will ask the judge, the court, to order the gatekeeper to comply with the DMA obligation, to stop a certain behavior, okay? That is clear. Then what about another type of remedy that we have in competition law, especially when we talk about vertical agreement, so that the contract is null and void. So we don't have anything in the DMA comparable to Article 101, paragraph 2. On the other hand, it's a general principle of law, I think recognized in most of the countries, that any contract cannot breach public law. So we would argue that indeed a breach of the DMA obligation could also lead to the invalidation of some of the contract, or the entire contract or part of it, which is in breach of the DMA obligation, since the DMA is part of public law. What about damages? So clearly, when we talk about private enforcement, we always think about damages. Now, that has been the rhetoric of the European Commission in competition law for the last 20 years. Are we going to have damages for breach of the DMA? I don't think so. And even if we will have them, that will start very in futuro anteriore, so really far in the future. So why? So first of all, because generally, as Francisco was explaining this morning, generally speaking, we must have to have damages, some kind of fault. Okay, it's not difficult to prove because we have the DMA obligation are clear. That will not be a problem, but we must establish a causal link. And the most difficult aspect will be the damages estimation. So here we don't have a cartel. We don't have a price overcharge which is transferred throughout the production chain. Here we are talking about loss of profits for business users who are harmed because of a violation of the DMA. And we all know how difficult it is for the economists to estimate loss of profits and to bring the case to court. Then the second difficulty is a time difficulty. Okay, so the damages can arise after 6th of March 2024, okay? Not before. So we will have to wait a couple of years before this really harm is caused. And then in terms of actions, clearly we can have follow-on actions where the plaintiff starts an actions after a commission or a competition authority sanctioning a behavior of the gatekeeper in breach of the DMA. But also standalone actions where mostly business users harmed by the gatekeeper breach of its obligation will go to a national civil court. Then legal framework. As I already mentioned, we don't have any procedural rules about private enforcement of the DMA. Is the damages directive applicable? The answer is no, because the damages directive is applicable to damages for breach of Article 101 and 102 and national competition rules. So here we are really full in the world of procedural autonomy, as Lena was explaining this morning. It's up to the member states to design the rules applicable to private enforcement cases for the DMA. We will see in the next slide that Germany has extended recently the application of the damages directive to private enforcement cases concerning the DMA breaches, but this is a sort of autonomous legislative choice by Germany. Maybe other member states will follow the same approach, maybe not, we don't know. And as usual, we have procedural autonomy, but then we have these two principles which Giorgio discussed yesterday at length, which stand in the air, so affecting equivalence. So we will see how the Court of Justice will apply them. We could argue that the case law of the Court of Justice that was adopted about private enforcement of competition rules before the damages directive could be applicable mutatis mutandis to the private enforcement of the DMA. So it's clear that the Court of Justice will rule that any individual has the right to go to court to claim damages compensation caused by a DMA breach, at least in theory. Then we know in practice that end users probably will not have legal standing, but at least in theory, this could be I think, an extension of the case law of the Court of Justice. And generally speaking, because of the principle of effectiveness, it's very likely that the court will, on a case-by-case, via preliminary ruling, argue that limitation to the right of end users and business users to go to court to start an actions because of a breach of the DMA will be considered in breach of the principle of effectiveness. Very briefly about Section 13 of the GVB, as I already said, Germany amended its German Competition Act in October 2023. And very interestingly, there was an extension of the provision of the damages directive to damages actions involving the breach of the DMA. Okay, so we have now an extension of the binding effect, so Article 9 of the Damages Directive, binding effect of the Bundeskartellamt decision and also decision of other competition authority and also of the European Commission about breaches of the DMA, which is binding now for national civil and commercial court in case of private enforcement cases. We have the same rules about the disclosure of evidence that we have in the Damages Directive, the fact that the file of the Bundeskartellamt in a case concerning investigation for a breach of the DMA will have to remain confidential up to the end of the investigation. So the rules are basically the same. There is simply an extension to private enforcement of the DMA. We don't have a couple of rules, so we don't have this rebuttable presumption of harm caused by a cartel, but clearly we don't have a cartel in this case. And interestingly, we don't have Article 17. So we don't have, at least in the German legal framework, the possibility for the competition authority to quantify the damages caused by a DMA violation. Clearly, we already said before that so far no competition authority has carried out this type of functions even under the damages directive. So it will be even more unlikely under the DMA to do that. Last slide. So in the DMA, we have in Article 39 also a sort of extension of the cooperation mechanism that exists between national courts and the Commission under Article 15 and 16 of Regulation 1/2003. And I personally think that this type of cooperation mechanism will be very important when we talk about the DMA enforcement. Why? Because we can, since the DMA designation lasts for only 2 years, and then the Commission has to, for instance, review if a company still has the status of gatekeeper. In the meantime, we can imagine that we have in a national court an action for infringement of the DMA obligation going on. So the national court, the national judges could ask for information from the Commission. So these tools have been used sometimes, not always, in competition law cases. I expect when we talk about private enforcement of the DMA, this type of cooperation tools will be more useful, let's say. Also, we have the equivalent of Article 16 of Regulation 1/2003, the fact that national courts, or in this case, national civil courts, cannot take a decision that runs counter to a Commission decision under the DMA. So clearly, if the Commission identifies a breach of the DMA obligation by gatekeepers, then we have a binding effect for the national civil courts in a private enforcement case. So I will now like to move to the conclusion so that we have a bit of time for questions and answers. So we talked today about the Digital Market Act. It has 2 main objectives: ensuring fairness and contestability of digital markets. Remember that the DMA can be enforced in parallel to competition law. So we will have the 2 legal systems working in parallel. We'll see how it will work in practice. It's an asymmetric regulation. So only large platforms, the so-called digital gatekeepers, are subject to this list of obligations mentioned in the DMA. What are the obligations? Article 5, self-executing obligations. Article 6, obligation that could be further specified by the Commission. Article 7 are the interoperability obligation for communication services, and Article 14 is the obligation for the gatekeepers to notify every new concentration, every new acquisition to the Commission. Remember that we talk mostly about behavioral remedies, fines, maybe in the future, structural remedy, almost impossible. And remember that the DMA will be enforced by the Commission, which will designate the gatekeepers and clearly also check the enforcement, but also by some competition authorities in the member states where the member states will empower the competition authority to carry out investigations about breach of the DMA obligation. Then we focus on the DMA private enforcement, which is coming. Don't worry, you will have job to do, at least those of you working in civil and commercial courts. So we are talking about civil claim started mostly by business users for violations of the DMA obligations by gatekeepers. We don't have any rule about private enforcement in the DMA. Is it a problem? No, as it was not a problem for the direct enforcement of Article 101 and 102 before the damages directive. Okay, even today we don't have a complete legal framework for private enforcement of EU competition rules. What is at the moment debated is whether only the obligations which are self-executing, Article 5 and Article 7, should be subject to private enforcement, or whether also Article 6 should be subject to private enforcement case. Who are the possible plaintiffs? Today we have argued that more likely will be business users, very unlikely to be for end users, even if they can rely on the new representative action directive. And in terms of remedies, will be mostly injunctions. Damages will be very unlikely in the near future. Procedural rules don't exist at the moment. We have the example of Germany, which has extended the damages directive to the application of the DMA. We will see if other member states follow the same example.